All right, we are here with Mauricio, Premier Law Group. Even though maybe explain the T-shirt.
Oh, you know what? We actually, I don't know if you know this, but I have a podcast now called Drunk Real Estate, and
Okay.
it's three other guys. It's Jay Scott, AJ Osborne, and Kyle Wilson. And last night we had Kathy Fetke on, and I actually saw the shirt. We had this shirt this morning. I'm like, man, I should have worn this last night, and I just threw it on today. So I don't have an old Capital T-shirt though, James. You gotta give me some swag, man. You gotta give me. I'll wear it, man. You gotta give me some swag.
So we usually don't make shirts for the conference, but so we do a charity tournament every year.
Okay.
And so the first 2 years we did basketball. And we had some injuries sort of post-COVID. some of the older guys got injured. We had some knees, Achilles, everything. So this past year we went bowling. No injuries.
Better. I mean, dude, come on. The average multifamily investor is out of shape, right? You gotta realize that. I mean, it's not exactly the poster child for health when you look at multifamily investors. I hope I'm not offending anyone, but that's just true. Even me.
Well, the thought is, hopefully, when you invest in multifamily, you should have more time than previous deal.
You should.
So
you should.
I see it as like a lot of people will usually get in better shape once they've done a couple of deals and they have a little bit more time than just the normal 9-to-5 job. So.
I think look, from personal experience, time is always the excuse. And then I got time and I still didn't do it. So.
Well, we need another motivating factor. So before we get in there, I think I saw a picture on Facebook of you. Do you have so it's your wife and two girls, or is it am I looking at that wrong?
So so Heidi and I got married in Belize, and so we took this really cool picture that both of us are laying in the water, actually in our full on. She's in a wedding dress, I'm in my whatever I was in. And we're laying there, and it's a really cool shot. And so we recreated that shot today, or whatever, it was like 3 months ago, whatever, with my kids. And my kids now are 9 and 7. I got 2 girls. And so we literally put me and Heidi the exact same position as that old photo. And then we just added, both of our girls there. And I think it came out really cool. And I posted a side-by-side on my Facebook. And it kind of blew up. But it's a cool shot. I got man, I wish I could give the photographer's name because I should give her credit, but she was amazing.
Was she were you guys in Belize again, or were you?
No. We were here in Temecula. We just did outside of Temecula. Beautiful field. It was like a somebody's house, somebody's land or whatever, but it's just tall grass. It was like, it's right out of a painting. It was really cool.
Well, so when you're not with the girls, you're doing PPMs. Working with syndicators.
Look, this is one of my pet peeves, man. I don't just do PPMs, right?
All right. Here we go. All right.
I make sure real estate syndicators fully comply with federal and state securities laws. I always joke that my job is to keep them out of jail. The reality is, unless you're committing fraud or whatever, you're probably not going to go to jail. But it's not just PPM, right? It's not just banging out a document. That's one of the things we do. I always say it's about 20% of what we do. But a good securities attorney should be doing way more than just banging out docs for you in 3 or 4 days. They should be making sure that your entire structure is fully compliant. And trust me, James, I know, I like to think of myself as somebody who does a pretty decent job of simplifying stuff and making these kind of complex, esoteric securities laws somewhat easy to understand, but they are complicated. And there's like I always call it a bag of stuff in the back of my head that I'm constantly going through. And most of the time they don't pop up, but that's what you're really paying the attorney for, is just to make sure that whatever you're doing, whatever loan product you're offering them, just make sure that there's no red flags or just something that needs to be disclosed to the investors, because that's really what you're looking for, is the compliance piece, not necessarily banging out a document that you can get on the internet.
So you said 20% is PPM.
Yeah.
What is the other 80%?
Well, let's talk. How long do you have? How long do you have?
No. I mean,
like somebody. Well, first of all, people come to me, for example, even before you get to the securities, people come to me. It's like, you know what? This deal's kind of small. It's only $1 million or $2 million. It's all my friends and family. I think I'm going to do this one as a joint venture instead of as a syndication, for example. Okay, well, you don't get to make that choice, right? Whether it's a joint venture or a securities offering, the facts are the facts. So however you've decided to structure your deal would dictate whether this is a joint venture or security. You don't get to make the choice, right? You probably heard, I know, Tom Wheelwright, if you want to change your tax, change your facts. It's the same thing. If you want to turn a securities offering into a joint venture offering, you got to change the facts, because if you've just got a bunch, a couple people doing all the work and even one passive joint venture investor, that's going to be a securities offering. The incredible, obscene sometimes amount of code GPs that are on deals. That's another red flag that you've got to think through. It's like, how many GPs do you have? Are they all actually doing substantial duties? Are they actually contributing to the efforts of the deal? Or are they just raising money for the GP team, right? At some point, once you get past a certain number, no magic number, but I would say 5, because that's one of the numbers that the SEC threw out for joint ventures. But so once you have more than 5 people in a GP team, it's not impossible, but it gets harder and harder for you to justify that you're actually in there to be a legitimate co-GP and not just in there to raise money. And so if you're a big money raiser coming in as a GP team, you got to make sure your securities counsel is advising you as to what duties are you doing? Is that enough? Do you need to be doing more? Is that going to raise some red flags of you just being a capital raiser and therefore needing to basically have a broker-dealer license, which you don't want to have? So that's like one of a million scenarios. What's going on right now, for example, a lot of people are doing what we call fund of funds, because people realized early on that they were kind of violating the securities laws on the GP side. There's way too many co-GPs, way too many people just raising money, way too many people getting offered, hey, if you can bring in this much money, I'll give you 5% of the deal. If you can bring in more, I'll give you more % of the deal. And so we were, not just me, but actually all of the securities attorneys that are going to be at your conference, we were all saying, look, one of the ways you can get around that is just kind of do a fund, right? So why don't you put together your own fund and invest that into somebody else's deal? So a lot of people are trying to do that now, but they're also doing, not saying it's wrong, but there's a bunch of compliance, not just PPM docs, but you're an investment advisor. So now, because you're investing in securities, so now I got to worry about, do you need to register as an investment advisor in your particular state? Well, let's look at the state. There's exemptions. Are you just basically raising money for that person and acting like a broker dealer, and there's really no value that you're adding? If you just put together a structure and you're raising money for James's deal, and James is paying you more money and you're pocketing that money, you're basically, all these little compliance things that are out there. When we go through a deal, I'm constantly running the deal against that bag of, I don't say bag of tricks, bag of information that we have in the back of our heads. And every so often it's like, whoop, that's kind of let's discuss this because this is a red flag. Or, another thing we do a lot is we look at the underwriting. Like, I know you look at the you've done some amazing videos, by the way, James, on sample underwriting as you underwrite deals. Well, we do the same thing. We go through the deal, not to figure out if it's a good deal or not, which is what you're doing, but we're looking for a story. Like, the underwriting tells me a story. If I see, for example, I don't know, like an insurance line or something, or some expense line item that's just kind of consistent, and then suddenly in one particular year it flies through the roof or goes way down, you got to ask that question, like, why is that happening? And a lot of times when you ask the question, why is this happening, or why is that happening, they'll tell you, oh, because we're doing X, Y, Z. Oh, well, that's maybe something we need to disclose, or maybe that's something we should talk further and see this other stuff. So we're constantly looking at the business plan, the underwriting, the structure of the deal, who the players are, what the loan product looks like, and seeing what it is. Are there any red flags from a compliance standpoint? And just making sure that we are actually disclosing all of that nitty gritty stuff. Because as you know, James, a PPM is just a conduit. It's just a pipeline almost. I can think of a pipeline to give disclosure. So you're putting disclosures in that pipeline so it goes to your investors. If you don't put the right disclosure in there and you don't know what questions to ask or pull the information from the sponsor so I can put it in the PPM, then you have a deficient PPM because you haven't disclosed all the facts. Right before we came on, James, talk a little bit about, you were seeing in one of the news articles about some syndicator that got into trouble because they didn't disclose that they had one of their compensations was relating to, I think, they had a brokerage firm or some relative at a brokerage firm. What was it, James?
Yeah. Basically, it's a self-storage group, and they were buying a whole bunch of self-storage, and usually there's closing costs and things like that, but then they weren't disclosing the fee that they were paying to the broker.
Right.
So I'm not sure if it was on the buying side or listing side or what have you. Either way, they weren't disclosing, and it ended up being, millions of dollars. And then the SEC came back with a fine of, $20 or $30 million against this one group. And so, and there's nothing. So this was, I skimmed the article, but the article basically, this was in their first 2 funds. And then now they're raising like a huge fund for number 3. And they were like, yeah, we're still using the same brokerage company and we're still paying them, but now we're going to disclose it.
That's exactly right. So that's
it wasn't necessarily that it's wrong.
That's the thing about the disclosure part is when you don't do it. Look, I you know me, I wrote that ebook, The 5 Things Every Syndicator Must Know to Stay Out of Jail. And the odds of you going to jail are unless you're doing something obviously intentional. But I purposefully use that harsh language because just to show that, the consequences are still dire. So in that example, you could have done everything right. your investors may have lost, or your investors may have lost. Oh, that was you. The investors may have lost money because of something that nothing to do with you. You know, whatever, the market crash. There was a fire, like whatever it is. You didn't do really. You acted reasonably as a sponsor. Really not your fault. But because you failed to disclose or failed to give all the information you were required, so for example, in that case, the person failed to disclose the brokerage relationship, then you are in violation of securities laws, and you're essentially guaranteeing the investor's return, because the real remedy or the real punishment for doing an improper offering is what we call restitution, which means you've got to return all the investor's money plus interest plus fines and penalties, which is what the SEC comes into. But so I always ask the question from stage is, do you really, who wants to guarantee the investor's return? Like they're giving you 100 grand and you're going to guarantee them that they're going to make whatever the legal interest rate is, 8-10%. Who wants to do that? Of course, nobody wants to guarantee their investor's return, but that's what you're doing when you're not doing it correctly or you're not fully disclosing everything. And so it just boggles my mind sometimes, because I know a lot of folks end up going to some really discounted service, and it's like, oh, they'll just bang out a PPM for like a third of the price and then a third of the time. And it's like, the only reason they're doing that is to save a few bucks. But the risk reward ratio to me has always been out of whack, because if you're raising, like to this guy's point, he's raising, I don't know, actually you said the fine was 20 million, but let's say you're raising $5 million for a deal.
No, hundreds of millions.
Yeah. So in that case, imagine like your risk. And again, this guy probably didn't even lose money or didn't lose, but if he lost all the investor money, he would be on the hook for $100 million, right? All so that he could save. Probably at that level, it's probably, you know, the compliance is probably more like 40 or 50 grand, but like just to save a few bucks. And so for syndicators in our world, you're trying to save 5 or 10 grand, which by the way, the project's going to pay anyway. And then your risk is so your reward is 5 grand, 10 grand, 15, whatever the reward is, but your risk is 10, 15, $20 million, because that's what you're guaranteeing plus interest plus penalty to the SEC. So it always baffles my mind. Same thing with real estate attorneys. I'm not a real estate attorney. I don't do the transactional work. But I know so many sponsors that just look for the cheapest real estate attorney out there, and they end up spending 3, 4, 5 grand on a real estate attorney when a decent real estate attorney is going to cost you 10 to 12 grand. And some of my clients spend 15 or 20 grand. So you got to ask yourself, well, what's the difference between an attorney that charges 20 grand and somebody that charges 3? It's not that they're 10 times cheaper. It's because they're doing, the one that's charging more has more experience, but they're also doing a lot more than just looking at your contract and saying, yeah, there's no spelling errors, right? They're actually representing you. They're looking at the loan documents. They're advising you. Now, for example, the cap rate issue or the rate caps that we've been talking about, that's been a big issue over that. A good real estate attorney would have been advising, hey, are you sure you want to do? There's a risk. You really should get some more insurance, less insurance. So all that to say is that people are, again, on the real estate side, are trying to save 5 or 10 grand on a real estate attorney. Some don't even use a real estate attorney. And so your reward is you're saving 5 or 10 grand from the project. Again, it's not even coming out of your pocket. But the risk is if something goes wrong, you're on the hook for tens of millions of dollars. The risk reward ratio to me has just been a really head scratcher over the last couple of years.
Yeah, I mean, it's, a lot of these deals, it comes across all the deals, right? It's, what type of loan you choose, what type of legal team you choose, what type of broker you choose, what type of property you buy, all across the board. Yeah. The risk return could be way off. Yeah. But we do have a couple of people joining us live. So I think Trevor or Carlos, you guys put in any questions you have here for Mauricio.
By the way, I had no idea we were going live. If I knew we were going live, I wouldn't have had so much coffee. And
no, you're good. You're good. So we talked about sort of funds of funds being become more popular. What about I don't know. So a lot of people will raise money through a 506c. And that will be accredited investors. It allows you to advertise. Are you seeing more people do B versus C? And then talk about the definition of accredited investor, is that still the same? I feel like they added a test or something. So I guess you're going back.
Let's talk about that because so this is interesting. So I'll give the definition in a second, but let me give you the punchline real quick. There's 2 things going on with accredited investor that's going to happen here. Actually, one of them might happen as early as next month. One is they're going to raise the limit. They're going to update the definition, and the rumor has it, and there's a big belief that the number is going to be raised. So instead of being $1 million, it's going to be something more in order for you to automatically qualify as an accredited investor. Okay. I think the number is going to be 3 million. Okay. And the reason I picked that number, I'll tell you in a second why I picked it. I think the accredited investor is going to go up to 3 million. So a lot of people who are accredited today are not going to be accredited next year. But there's an alternate way. So if you do fall into that trap that you are accredited now but won't be next year, or if you're just not accredited now, there's going to be an alternate path for you to go take a test in order to get the accreditation status based on your knowledge and expertise versus just your financial wherewithal, which makes sense because, we all know, James, people who are the smartest people in the room and, they're the richest people in the room and they're the dumbest people alive, and people who are really modest means are really smart and know more about investing and risk as everybody else. But let's talk about them independently. So the first is a test. The SEC has already actually passed the rule that says there's going to be a test. They just haven't come out with the details of it. And it's been almost 2 years now. So it's just kind of been sitting on their desk for a while. But the rule is already in existence at the SEC level. I think because they sat on their butts or still are sitting on their butts, again, change of administration, changing priorities, Congress has gotten involved. So Congress, not Congress as a whole, but the House of Representatives in June of this year passed a bill that basically there's two of them. One was called the Accredited Investor Definition Act, and the other was called the Equal Opportunity for All Investors Act, I believe. And they, similar to the SEC, passed a bill that said, hey, we're going to add this test requirement that if you pass this test, which has to be, somewhat complicated, and you're learning about securities laws and what the exemptions are and what the risks are. But if you pass that test, you're going to be able to become an accredited investor based on the passing of the test. That's only passed the House, and now it's sitting on the Senate. But what's interesting is that those bills passed with an overwhelming majority. I mean, it wasn't even close. Like the House one that went out, first one went out of committee, it was 41-3 or 47-3 or something like that, and then just passed on unanimous consent. And then the other bill passed, again, I don't remember the numbers off the top, but 200 and something to 80 or something. I mean, it was just overwhelming. So I think that's making its way now. It's sitting in the Senate Finance and Banking Committee. I think that's going to pass. So I do believe a year from now, we're having this conversation when we're talking about next year's Old Capital event.
Yeah.
There's very likely there's going to be a rule already that's going to be allowing people to get accredited investor status with a test. On the flip side, one of the reasons I think the SEC hasn't passed that they passed it, have been sitting on it, because some of the committee members wanted to also update the definition of accredited investor. It's been on the agenda for over a year now. They were supposed to talk about it last year. They punted it to April of this year, and now they just punted it again to October. There was a Bloomberg article that said that they were thinking about increasing it to $10 million, and that gathered a lot of attention. That was about a year ago, that the definition of accredited investor was going to 10x. It was a little bit of a misleading article. It really had to do with, if you, not $10 million of accredited investor, but if your deal was more than $10 million, there was going to be some increase. And maybe that's still going to be the case. But the math I did, and I don't know if anybody else is talking about this, but, when they passed the accredited investor definition, it was 1982. So in 1982, they said, hey, an accredited investor is going to be $1 million in net worth. That was the original one, right? Then they updated it many years ago to exclude primary residences because everybody had so much money in equity. They took that out. But really, it's been $1 million since 1982. So all I did in my vast wisdom is I went on Google and I just, figured out how much was $1 million today based on 1982 dollars. And the number came out to 2.7, 2.8 million if you're using official CPI numbers, which we can get into as another issue. But so that's 2.8.
And nobody even cared about CPI until about 2 years ago.
Yeah. So, maybe it's probably way more than 2.8 million, but using official CPI numbers, that's 2.8 million. So I'm like, look, it makes sense if you just adjust it for inflation, you're at about 3 million. Is it going to be 3 million? I have no inside information. It might be 2 million. It might be 5 million. It might stay the same. They might even, just have something for a certain limit. Like if you're going to be taking more than a certain amount of money from an investor, there's all kinds of ways they could go. But my gut tells me it's going to increase. And to me, adjusting it for inflation makes a ton of sense. So I would not be shocked if they increase it, at least originally, to 3. Maybe there's so much pushback, they'll come back down to 2 or 2.5 or 1.5 or whatever. But it is going to go up, I think. So if you're barely making accredited investor status with $1 million, there's a good chance you may not be accredited next year, which means you just got to go take the test.
So I'm going to pull in some comments from the live audience.
Uh-oh.
And so I did understand.
Trevor's in the house.
I didn't understand this comment until I did. So.
Yeah. Nobody looks good in orange, man.
Nobody looks good.
And again, I purposefully chose the word. In fact, I own the website stayoutofjail.com. If you want to copy the book, I'm going to throw that out there. Stayoutofjail.com. But it was just because I feel so many people out there are just ignoring the securities law. They don't think they're a big deal because nothing's really been happening. And it's like, oh, everybody else is doing it. Let me do it. And I do believe that we haven't really had any major issues in the real estate world since the great financial crisis of 07, 08, 09. Yes, right now we're starting to see some struggles, right? It's the market's turning a little bit. A lot of people got caught off sides who bought a couple years ago. But when we go into a full-blown, which we're kind of already seeing, right? They're starting to trickle. I see every day now more and more sponsors, people that you and I know, getting into hot water and getting into trouble, not because they're defrauding everyone. I don't think it's just, they just got caught buying at the top of the market and got caught off guard with the high interest, the rising interest rates and the speed at which they rose. But I think when that starts to happen and there's more and more lawsuits happening, when more and more investors lose money, because as you know, James, right now we're at the stage where we're kind of getting the cash call stage, right? So we're in the stage that we've got trouble. The banks are involved. Hey, you're getting into, what do they call it, James? The little black box area where you're kind of falling below your DCSR. And
sure, yeah.
Yeah. And so that was first. And now it's like, oh, crap. We need more money escrow. We need all these things. Crap. Okay, now we're into the cash call phase. So some people get through that system, and then at some point, it's just going to work its way out, and people are going to start losing their home, the properties to foreclosures, which is starting to happen, or they're handing over the keys, or they're short selling to other investors, and eventually you're going to get to the point you're going to have investor lawsuits. And I think that's where people are going to realize, oh crap, these securities laws really do mean something, and it's not going to be the primary thing. I was talking about this yesterday, actually. It's not always going to be the main thing. Like if you, for example, if you've been raising money for a co-GB team without doing the proper, we're not really complying, they're probably not going to nail you originally for that. They're going to nail you for something else. The investor complains, they've lost a bunch of money, they open up an investigation, and then they find all these other violations. Oh, you were advertising on social media when you weren't supposed to. Oh, you weren't disclosing this. Oh, you were capital raising. No different than I live in California, so unlike you guys in Texas, I've got a lot of regulations here. But like, I don't have a front license plate on my car, which is a big no-no, right? But I never have gotten pulled over for driving without a front license plate.
What is it? I don't understand that. Like,
yeah.
It is a law in California.
Yeah. You cannot drive without, number one, a front license plate.
That, Mauricio, this is live. You know that, right?
So, yeah. So you can't drive without a front license plate.
They will use this in court against you.
You can have a certain level of tinted windows, but on the front, you can't have any tinted windows on the front, or maybe there's a degree of tinted windows.
Yeah, it's maybe 30.
But I've never gotten pulled over for my tinted windows, and I've never gotten pulled over for not having a front license plate. But believe me, when I get a parking ticket, they tack on the no front license plate. Or if I get pulled over for speeding, they tack on, hey, you've got your windows tinted. That's what's going to happen in this world. You're going to get pulled over because you lost investor money, and you forgot to disclose. They're going to allege you never disclosed that I could lose my money. They're going to open up an audit. There's going to be an investigator involved, probably from a state regulator, not the SEC. State regulator is going to come in and start doing a deep dive in everything, and that's when they're going to uncover, wait a minute, how come you guys have 17 co-GPs? Right. What exactly was everybody doing? And show me what everybody was doing, and then be like, oh, yeah, this guy really wasn't doing much. He just brought in $500,000, and that's why he owns 5% of the deal.
I think I heard on the podcast that I think it was Al Capone or something. Like, they couldn't charge him with murder. Correct. They charged him with like tax evasion or something. Like, they needed something. They had to get him on something. And so,
you want to get really political?
Are we going to Trump or no?
Yeah, everybody's like trying to get, and I'm not a Trump fan by any means, but it's like everybody's like, oh, he did insurrection, this, insurrection, that. Like, but they didn't charge him with insurrection because they can't prove it. So then they go after some other argument to try and nail him. So I think anyway, that's what's going to happen. Same thing with social media, right? People who are, kind of violating the social media, who are doing 506Bs, and they're just crossing the line, I think, on posting stuff that again, the SEC doesn't have like an intern in their office monitoring all the social media stuff. But if you do get nailed for something else, and they open up an audit and they review everything at that point, look at all the emails, they're going to come up with that. You know what else they're going to find, James, which is something that I think people forget, especially when it comes to this capital, getting compensated for raising capital, is all those emails, and more importantly, those spreadsheets that syndicators have about, oh, this is how we're going to, and they have a little line item on their spreadsheet that we're going to give away 6% or 5% of the GP to the capital raiser. Or when somebody's coming on board and they're negotiating it and there's emails going back and forth, those aren't privileged, right? Those aren't protected. So in an audit, when the SEC requests and gives you a subpoena to send all the emails and all the spreadsheets, they're just going to see right there that there was a negotiation between the main sponsor team and this co-sponsor that came in at the 11th hour to bring in $500,000. That really they came in to raise the $500,000, and they really aren't doing any substantial work in the deal. So but again, it's a full circle. That's just stuff you're not going to pick up by just banging out a PPM. That's something that you when you're discussing it with your attorney. And again, I'm not the only attorney. There's going to be a bunch of great security colleagues of mine at your event coming up next month. We're all going to say the same thing, which is it's those conversations and that consultation and advice that you're really paying for.
Okay. Well, Trevor, I appreciate the comment. We did have a question here, and I'm scratching my head a little bit just because I can't exactly figure out which way you want to go with this one. Carlos, maybe put it in the comments.
I'm just saying, guys, what can we do to fight back against all these new interest rates and SEC? Oh, do we have to go along with it? Well, you could talk about on the interest rates, you don't have a choice because I can guarantee you,
it is what it is. Right?
James is not going to, he's not going to come back to you and say, look, we found you a product here, but we'll take 5% instead of 7 or whatever, whatever it is now. Yeah. So on that one, you're just not going to have a choice because they're just not, people aren't going to
maybe forget the interest rates. Talk about, I'm not sure what he's referencing in terms of.
I think it's like, well, the question is, do we just look? Carlos, I agree. There's the main assumption here is that there's been a lot of new SEC regulations, and that's absolutely correct. They keep coming out with more and more regulations, making it harder and harder to raise capital, especially, for example, the accredited investor. I mean, we're actually a little bit surprised that this hasn't come up early. But if you look at the statistics, the amount of companies that the public market company has just collapsed ever since 506C came out. Because why would you go public and have to go through all that, go through Wall Street, right? So it's really Wall Street that benefits from everybody going public. Now you just do a private offering. And as long as you have less than 2,000 investors, you don't have to go public. So as a Facebook or some other startup, forget about real estate, but as a startup, you can hang on to being a private company much longer because number one, it used to be 500 investors. You had to go public. Now it's 2,000. So as long as I keep it under 2,000, and if, of course, I'm raising capital from, I can do a 506C and bring in billions of dollars, right? So I'm surprised that Wall Street hasn't lobbied. I mean, I think they've been lobbying for all these years, but they finally have gotten to the point where the regulators are actually making it harder to do our work, Carlos. So I agree with you. A lot of SEC regulations coming up, but it's like, do we just have to go along with it? Unfortunately, the answer is yes. I mean, if there's a new regulation, you've got to comply with that regulation. Otherwise, you'll be non-compliant. Again, I don't think you're going to go to jail, but you're going to, again, you're guaranteed, if you don't go along with it and you're raising money, you're essentially guaranteeing your investors' returns, because if it goes south and you violated one of those regulations, then the remedy for your investors is they get all their money back plus interest, which probably means you don't have it, which probably means you end up filing for bankruptcy. And, it's just not a good thing. So the way to fight up, the only way really to fight it is through obviously the voting process. I mean, these regulators are obviously appointed by government agencies and politicians, and that's really the only way to do it is either start a lobbying company or donate to whatever lobbying company out there that is representing your interest, or get out the vote and get new people in there so they can put in regulators that are a little bit more hands off.
All right, Mauricio. Carlos had a follow up here. So he's doing a 506C, and I guess the question is, should the SEC attorney be helping him? That was the quickest no.
No. So no, your SEC attorney, they have one job and one job only. And if they're purely an SEC attorney, that's making sure that you're raising the money in full compliance with federal and state securities laws. Now, if you're doing a 506C, that preempts the state. So if you're in Georgia or whatever state your investors are in, you don't have to worry about those state securities laws other than the anti-fraud provisions. So you obviously can't make any massive representations. But 506C is a federal rule. But your attorney is just making sure you're following the rules of 506C, that you're following all of the rules, broker-dealer rules, or, whatever other compliance thing that's in the bag of tricks back in the attorney's head. But they're not going to be out there helping you find a credit investment. In fact, we're under the same rules as you are. Like I would love to be able to point passive investors to my clients and take a referral fee or a cut or whatever like that, but we can't do that either, right? So it's not our job, and nobody does this. Plus, there's liability involved too. Like we're not going to be recommending. Now, if a client comes to me and says, "Hey, I've got $100,000, I need to put it somewhere. Do you have anybody who would you recommend?" I'll make a couple of introductions or something, but it's not really our job to go find accredited investors for you. That's just marketing and relationships. And by the way, that's another misnomer too. I think the idea of doing a 506C and that you're just going to post something on Facebook and suddenly you're going to fund your deals. I mean, that's also a misnomer. I mean, the way you raise money is, as you know, James, just like everything else, is through relationships. And so you want to be able to use the advertising methods to get into relationships, to invite them to events, invite them to meetups, and invite them to webinars, and really make it easier for you to enter into that relationship, or get them to know, like, and trust you through ads, or becoming the authority, that kind of stuff. It's kind of difficult to just throw up a couple of posts and a webinar and suddenly, raise a ton of capital just that way. It takes time still.
Carlos, thanks for the questions.
Well, wait, I'll just tell you one quick story though. I used to work used to be a managing partner actually at a mobile home park company, and one of our marketing guys had said, he said, "Hey, we should do Google ads for raising money." And I'm like, there's no way somebody's going to just, come across a Google ad and invest, a bunch of money. And man, boy, was I wrong. We put some ads on mobile home parks. People would, who had no idea who we were, would click on whatever value add piece. It would lead them to a phone call. They'd talk to the CEO, and boom, 200 grand, 300 grand. I'm like, so it can work. I just think that's the exception, not the rule.
It's becoming harder and harder.
Yeah.
I guess you could say. So I did want to, and so this was the question I had, was around, I think sometimes, or maybe this is just what I think, is that if you do a 506c, you're less likely to get sued because you're just you're getting money from accredited investors and they got money, right?
So let's just talk about that for 20 seconds. That is correct. That is correct. But it's not because it's a 506c. It's because all of your investors are accredited. Don't forget that the vast majority of 506b deals are accredited only. I pulled it up many, many years ago, but I want to say only 8% of 506b deals have non-accredited investors in them. Like the vast majority, like when JP Morgan and all these big players raise money, they're all accredited only. That's what everybody associates 506b with non-accrediteds. And that's not, you have the option to bring in non-accrediteds, but a lot of people, a lot of my clients use 506b, but only accept accredited investors only. That's what protects you, because your obligation with the disclosure requirements is much higher. That burden is much higher with non-accrediteds. So if you forget a comma here, you're going to be much more likely to be in trouble with a non-accredited than you are with an accredited. And to your point also, if somebody loses 1% of their net worth, if they lose $100,000 and that was 1% of their net worth, it's not a big deal. With a non-accredited, the odds are higher that 100,000 represents
10%,
all of it, or 50%, or some big number, and even losing. That's why even cash calls are a bigger issue with non-accredited, is because for a non-accredited to come up with another 10 grand is a much bigger deal than an accredited who's got multiple millions of dollars. So it has to do with the accreditation and the legal obligations that you have towards accredited investors versus non-accredited. That makes it a little safer, and that's why a lot of people don't take non-accredited, because they don't want to deal with the risk. The risk is there's a higher burden, a higher risk involved with non-accredited, which is another reason why you want to have a proficient securities attorney advising you when you're having non-accredited, because you really have major disclosures to make above and beyond if you just had accredited.
So I'm going to throw this out there. I know you're in California, but I'm going to throw this hook out there. You can take it or not, or you can swim right by this guy. So I think Grant Cardone was recently in a suit, or someone brought a suit against him. And I think it was similar to what we were just talking about. Just he's doing larger raises to the masses, really. And then, someone who put in $10,000 or something is now going after him, right? So they filed this big law. Do you know anything about that? I have not. I've just seen it on the outside, but
yeah, it's a little different. So, but that's exactly right. So Grant Cardone, if you follow his career, he started by just investing his own money. Right. Then he started doing 506c deals, meaning a minimum investment was $250 or $500 grand. And then he got into the Reg A business. And so because he's got a huge following, he actually uses a Regulation A+ exemption, which requires him to actually kind of do a mini registration with the SEC. But once he gets approved, which usually takes 6 to 9 months, and I think with Grant it took a little bit longer because he's a big public guy, he was allowed to not only advertise because he's got a platform, but he can also take non-accredited investors. So he's got that he's eating his cake and what's the thing? You can have his cake and eat it too, right? So he's able to advertise and take $5,000 investors, $10,000 investors, as long as he keeps that to under 500. And there's some limitations of how much they can invest, which is why they invest little, because they can only invest 10% of their income or net worth, whatever's highest. But so if you're making $60,000 a year on the income side, you can only invest $6,000 is the most you can invest. Right. And so what happened though is he got it through, allegedly, he got it through the SEC, and the SEC said, so with the SEC, what happens is you give your PPM, basically a PPM offering docs to the SEC, then you go back and forth. They say, yeah, you can't do this, take this out, put more, like they're literally overseeing the whole process. So on some of the stuff, he wanted to give some returns. He wanted to say, we're projecting a whatever 20% return or 3x multiple, like whatever representations you wanted to make. And the SEC said, no, you got to take that out. And so he took it out of the PPM and the docs. The SEC approved it, but then the allegation is when he went to promote it, he went back to promoting what the SEC told him not to put in there.
Okay,
and so
I got you.
That happened during COVID. And it's actually a class action. So it's not just one investor who sued him. He basically had a class, and so every single investor in that particular fund, it was just a certified class. That actually got dismissed right around COVID or right after COVID, and it got appealed, I think, all the way to the whatever the circuit, whatever the next level was. But it's back, so it got dismissed, but now it's back, and so he's back in the thick of it. So, but that was the issue, is that the SEC told him you can't say this, and so he took it out allegedly, and then allegedly he's saying it in his social media posts, and that's what the complaint is from these investors. But yeah, to your point, they're $5,000, $2,000 investors. Because you can do that with a Reg A.
All right. And then I feel like everything is chat GPT or AI driven at some point. Has that impacted your space at all, or nothing? Nothing yet.
It's going to really disrupt stuff. I mean, right now, I use ChatGPT a lot for my social media stuff. I mean, you can take, you can just grab this recording and put it in the ChatGPT and come out with a 6-point summary or whatever.
Right.
But I do think AI in general I think it is going to replace a lot of the stuff that us attorneys do. And we're actually working on some kind of cool stuff with AI, which I think is going to really make a big difference on not only, the cost that we were able to offer our services, but also the speed at which we turn it out. So we're actually in the middle of building some AI stuff out, which I think is going to be really cool. And for some, I do believe, like, there's some professions out there, I haven't done a video on it yet, so I won't name it. I think some professions, they're done. Like, there's no reason. I just think they're done. There's a lot of legal stuff that, with a good AI, and there's already a couple of legal AI tools out there where they can help you with the research, but the ones that rely primarily on almost like information and research, and just there's a lot of in the industry that are going to be in trouble, and it is going to get disrupted for sure.
Well, as everything that's disrupted, people just find other things to do.
Right. 100%.
Have you seen the technology used on the real estate syndicator space in any interesting ways, or like when you talk to people?
I haven't, but I know there has been. I mean, if I'm the least qualified to talk about that because I know if we had some AI specialists, they would already tell you some of the stuff some of the people are using, just from data mining, right? Just if you can get all that data into your AI, and then now you can find, just even finding deals, right? Underwriting, for example, is a great example. If you can put every single detail of every single house in the marketplace into your database, and then you can just say, hey, here's my underwriting model, go find me the properties that fit this underwriting model, and it'll just spit it out, and at least you get leads. But I'm the least qualified to talk about this, so I should probably shut up.
Well, Mauricio will be here in Dallas, October 4th and 5th for the conference, Old Capital Conference. So we appreciate you sponsoring. You're going to be up on stage for a little bit as well. So I appreciate you coming on today and answering some of my questions on the legal side. There was no prep. It was fired straight at him.
I didn't know it was live. Like I said, I didn't even know it was live. He's like, we're going live. And I'm like, we are? I'm like, all right, good.
So I appreciate you coming on. And what's the best way for people to reach out to you? Is it website, email?
Yeah, they can go to premierlawgroup.net. And if you want to schedule a coaching call with us, there's something there. Or I'm on YouTube a lot, just like you are. You definitely, if you're not following James on his YouTube channel, but I got a YouTube channel, Mauricio Rauld. And I just put a lot of content out there. So would love for you guys to go check it out, subscribe. And I put out at least 1 or 2 videos every week on syndication, asset protection, and some macro stuff.
All right. Thanks a lot, Mauricio.
Sounds good, buddy. Thanks.
Right.
See you next week. Next month.
Next month. All right. I'll see you.